firstly, thank you to the organisers for inviting me, and in particular, I note Heather and Robert and Linda as office bearers, and Rosalie, of course, seems to be the worker that I've been dealing with that knows what's going on. And also, I acknowledge the traditional owners of the area, which I understand to be Jagera and Turrbal, and also I pay my respects to the elders of the Indigenous community, both present and past. And I've been very fortunate to have known many very wonderful Aboriginal elders in my time and learnt an awful lot from them. And the people who are referred to in my book as agitators are those Aboriginal people who agitated to bring about change. And I'll talk about that later. But also, I just wanted to mention in my role as a lawyer, I found the Aboriginal field officers that worked for the ALS to be of tremendous significance and tremendous value, and many of them are passed on also, and people who gave a great deal to help in the role that I had to play and probably would not have achieved as much without them. I support the principle of reconciliation and suggest to you that there are two aspects of it. One is the moral aspect, and in that regard I would suggest to you that there have been crimes against humanity committed by England and by the state of Queensland, because the state of Queensland came into existence in 1859, and what happened after that was entirely the responsibility of the Queensland government, and continues through its successes until it's remedied. But also there is a practical aspect to reconciliation, and that is that our country will be a better country. People will live more happily together and engage and become more prosperous together if that reconciliation occurs. Now, one of the things I'm here about, of course, is my book, and it's called Adventures with Agitators. And the purpose of the book in the first place for me was to record the battles in the justice system waged by the Indigenous community over nearly half a century that I was involved. And that, I would hope, would bring pride in the Indigenous community in those agitators, because they're the people who brought about the changes. And if you think about it, for 2% of the population to have achieved so much in that time, without a single act of terrorism, which would have been the case in any other part of the world in the same situation, is amazing. And so I'm hoping that it will bring pride in Indigenous people in their own battlers, but also bring knowledge to the non-Indigenous community as to what really went on. And I think it's important that all Australians know what evils were done to the Indigenous community, and I really don't think that our education system or the general community carry that forward as they should. Now, curiously enough, by the way, I just wanted to add, I've had very little interest from the Courier Mail or any of the mainstream media in terms of my book, but lots of interest from people who are actually caring, sensible, sensitive people. Now, on a personal side of things, I'm not Indigenous myself. My grandfather came here in 1908. He was a stonemason from Cornwall. And my other grandfather worked at the Ipswich Railway workshops. My father left school at the age of 15 because there was no free secondary education in those days, and he got a job at the office boy at the hospital, worked his way up to becoming the manager of the Royal Brisbane Hospital, and was the manager in charge of the construction of the Princess Alexandra Hospital. And he then progressed himself in that field and got qualifications as a hospital administrator. So I actually wound up working at the Royal Brisbane Hospital as a message boy, running around the hospital in the old days before there was the technology. And I used to work in the Coles supermarket packing boxes on a Saturday morning. So I don't come from one of those families. In fact, when I went to university, I was the only person in my class who didn't go to a private school. I was the only one from a state school. There were no women, there were no blacks, there were no foreigners. It was all white, all people who had fathers who were judges or barristers or solicitors and so forth. And of course that's all changed a lot. But I wound up doing articles with a firm of lawyers at Stones Corner, and then I got called up for national service to go to Vietnam. And so I checked out what that was all about, and then realised that it was in fact a war of independence by the Vietnamese against the French. And because they were beating the French so badly, the French went to the Americans to try and get help to maintain their economic power in Southeast Asia, and that's what it was really all about. And so I rebelled against that, and I got involved in amateur theatre, largely doing theatre productions, a lot of them centred around the anti-Vietnam War movement. And it was in that context that I met Vivian Walker, the youngest son of Oodgeroo Noonuccal, as she is now known. And I became very close with them because Vivian took me home to meet his mum. He was in the theatre group, and if anyone ever met her, you'll know what an extraordinary, wonderfully powerful woman she was. And so I was overwhelmed by her, my own home circumstances being somewhat uncomfortable for various reasons which we don't have to go into. I found that acceptance in that family. And in 1968 I spent Christmas Day with the Noonuccal of Cherbourg Island, and that's when I began to realise that I could be involved in other things apart from being bored in my own life as I was. And I met Dennis Walker through that and developed a special relationship with them. And ultimately it led to my finishing my law degree, which I might not have done. I might have gone into professional theatre or something like that, because that was what I was more interested in. And they introduced me into being useful by finishing my law degrees. Now, the Cherbourg Island mob in those days, they had no land, no money, no power, and not much respect. And later in my talk I'll explain how that's been completely changed. They now have lots of land, lots of money, lots of power, and lots of respect. And it's a great joy to me to have seen that happen. And in fact in 2011 they got a native title determination, despite the fact that the state government maintained a policy until 2006 that there was no native title south of Townsville. That was their rule. So there was a federal court, there was a native title conference in Melbourne, and Justice North of the federal court was giving a paper. And at the end of his talk he asked for questions, and my question to him was that in ordinary civil proceedings, a party alleging fraud has the onus of proof of that fact at a higher standard than the ordinary balance of probabilities. And I didn't mention which state or which group, but I said that there was an instance where the state was maintaining that they'd killed all the males at a particular point in time, and that therefore there couldn't be a continuity of law and custom to go through to entitle you to native title now. So my question was to him, wouldn't that be analogous, wouldn't that be genocide, and would it therefore not be analogous to fraud, and therefore should not the state bear the onus of proof of that fact at that higher standard than the balance of probabilities? Justice North thought for a moment, and then he said, you know, he said, I think I'd want to have that argued before me before I want to rule on that. Now that was a signal to me that if we made an application in a directions hearing to the court for an order that on the trial of the matter, the state bore the onus of proving that they had destroyed the society of those people, and at that higher standard, then a high standard of proof, well then should we not be able to do that? We probably wouldn't get a cost order against us even if we failed. But on the other hand, if we'd made the application, you can imagine all around the world, everyone would be saying, did you hear about that place in Australia where they're actually arguing in court that they succeeded in a genocide and therefore they don't have to give the natives anything? I mean, so at that point the state changed their whole attitude. It started to negotiate, and they got it in 2011. And that is an example of taking advantage of the state crime that was inflicted on people. Now that mob have got tourism going, they've got the environmental repair going on the island, they've got 100 people working, local Aboriginal people working in tourism and the development of the island. I think it's absolutely wonderful. From my point of view, I first got involved, because of the Noonuccal, got involved in Tribal Council, the Brisbane Tribal Council, and the first thing I discovered was that the state government had divided the Aboriginal people and the Torres Strait Islander people. And the way they did it was to create these images in everyone's mind. So for example, the Torres Strait Islanders would come to me and say, you see them Aboriginal fellas, they won't work, they're lazy, you can't get them to take a job. And the Aboriginals would come to me and say, see them Torres Strait Islanders fellas, you can get them to work all day for bugger all and they're happy. You know, and they had these images of each other which were just exploiting and dividing people, and Tribal Council brought them all together. People like Don Brady, Don Davidson, Dennis Walker, Steve Mann, Lenny Watson, and those people, they brought them together and they got rid of that divide. I was involved in this theatre group, as I said, and we had an old house in Paddington, Latrobe Terrace, Paddington, for our theatre. We converted this old house into a theatre and lived in it as well. Next door, Tribal Council moved into the house next door. So then we had these wonderful parties together, and at the same time I also did some theatre workshops, black theatre workshops with people, because we were a theatre, and I went next door and said to them, do you want me to help with doing some theatre workshops, which I did, but only in Brisbane and only fairly limited, just to kick it off. Then they also, Dennis Walker, Sam Watson, Marlene Cummings, Cheryl Buchanan, Susan Chilly, and Johnny Cummins, I think, too. Anyway, the group, and they all got together and formed the Black Panther Party. And they wore these black berets and black sunglasses and black gear, and they'd go around doing black power salutes, and they terrified everybody. And what then happened was that in early 1972, there was a student conference on racism at Queensland University, and the students, as they did in those days and probably still do, were waffling and being theoretical and moving things. And I moved at the motion not to put the motion to be put, and all this sort of nonsense, until the Panther Party walked in. When the Panthers walked in down one wall, suddenly they all went quiet, and suddenly everyone wanted to be positive. So Don Brady got up and said, talked about the things that were needed, like a health service, a legal service, a housing service, and so forth. So then I got up and said, well, look, if anybody here has legal skills, lawyers or law students, and wants to help, come to my place on Wednesday night and we'll see if we can get something organised. And then from that, we then had another meeting, and at the meeting we organised a voluntary legal service that went throughout 1972 on a voluntary basis. And that was prompted very much by the Springbok demonstrations the year before, because in 1971 the South African rugby union team, an all-white team, was here, and there were protests because it was breaking an international embargo. And of course, as a result of that, people were saying, well, it's all very well pointing fingers at South Africa, but we've got the same thing here. Why aren't we doing something? Which really prompted the student activities. So it was a voluntary service in the first year, and I remember the first case we had as a voluntary legal service was a 17-year-old fellow from Cherbourg who had come down here by arrangement with the State Department of Aboriginal Affairs, and he was doing an apprenticeship as a carpenter. He didn't drink, he didn't smoke, he was a very decent, hard-working young man, and he happened to be walking down Queen Street at a time when some of the police still thought that Aboriginal people weren't allowed to be in Queen Street after 6 o'clock at night, and so they arrested him and charged him with obscene language and resist arrest. They didn't put an assault on him, just made it obscene and resist. And so he was our first case, and we had a lawyer go to court to represent him, and I'm pretty sure he was found guilty. But then, of course, what happens is they give a very, very small fine, because they know that there's going to be an appeal if you make it too harsh, so he got a small fine. Now, we first opened the office of the Aboriginal Legal Service in late 1972, and the first solicitor was a fellow named Ron Finney, who's passed away now. But on the 1st of July 1973, I got admitted as a solicitor in April 73, started to work in the 1st of July 73, and then about 3 months after that, Ron Finney decided he couldn't continue, and so then I got my old mate Wayne Goss to come in as the junior solicitor to me to work in the legal service. He'd also been involved in the theatre because we did articles at the same firm. I got involved in my theatre group, so involved in becoming an actor, and then we were involved in becoming the lawyer at the legal service. And then when he decided to be a politician, I said, good, you do that. I don't want to do that sort of thing. I'm quite happy to tell you what I think you should do, but I'm not going to do it myself. You know? The other thing I was going to say is that along the way through all of that, I found that one of the best learning experiences was actually sitting around a fire with a group of Aboriginal people and having a few drinks. Now, for example, there was a hostel, Brisbane Tribal Council had a hostel at Woolloongabba in Trinity Lane, Woolloongabba. At the back, there was a big open fireplace and logs and benches around in a circle. And we'd all sit there drinking and talking around the fire, and the backdrop was the skyscrapers of Brisbane as your backdrop. It was a surreal experience to be sort of talking about the ancient way of Aboriginal people while having that backdrop there. When we first started the legal service, we found we had a lot of problems with police. They really didn't understand what we were about. They couldn't understand why we were there, and they really hated us a lot. And of course what they would do is, if you rang the police station to say, is my client Bill Smith in there? They'd say no. And then you'd ring the watch house, you ring all around all over, couldn't find him, where is he? And it would turn out they just lied. So well, on one occasion, Wayne Goss got this thing that the clients weren't there at all. So he heard from one of the relatives that had gone to the Woolloongabba police station. So Wayne went to the Woolloongabba police station, went round to the back steps, went up the back steps to the fire escape, came in the back and said, gotcha, you lied to me, you know. So, and of course the other thing is verbals. If the police would just verbal people, he said he did it, and he says, I didn't say that. And the magistrates would always believe him, and I'll talk more about the magistrates shortly. But so I got involved in it at a very early stage, more by chance. And the other thing that I'm pleased about today, which is a surprise to me, is my old mentor, Huey Hamilton, here today. Now, in '83, Huey was the boss of the state, the state secretary of the Building Workers Industrial Union, which now is the CFMEU. Anyway, they were starting up industry super. And the Pajoki Peterson, who I'll talk more about later, he also was trying to stop workers getting any rights either. So he passed a law saying that industry super was not allowed to happen in Queensland unless all trustees were Queenslanders and 1/3 were independent. So I went to Huey and I said, Huey, I think it breaches section 92 of the Constitution, free trade between the states. Let's go to the High Court. Every lawyer wants to go to the High Court, you know. But Huey said, no, we're not going to do that. He said, he's only trying to waste our time and energy and exploit us for political purposes. And it'll cost us more than we get back even if we win. And in the meantime, the workers will get nothing. And if we do it that way, we've got local control. So I became one of the directors of BusQ Industry Super Fund, which continues to this day and has averaged about 10% over the life of the fund. It's got the best returns, the highest standard of integrity, and it's been a matter of great pride to me. And I'm very grateful to Joe for being a bastard, because if he hadn't been a bastard, I wouldn't have had that opportunity. And I'm grateful to Huey for the right reasons that he gave me that chance, and I really valued that. But the thing was, my contemporaries at the time, both with respect to Aboriginal legal aid and industry super, my contemporaries were saying, well, that's just, you're not going to make any money out of that. That's going to be a dead loss in time, money and energy. You know, why bother with all that? Well, here I am now at 73 next month, and retired a few years ago. Very grateful to the super fund who enabled me to have the retirement, and very grateful to the Aboriginal community who enabled me to write this book and enjoyed coming around talking to people like you. So I reckon I've come out really well on that. Now, I wanted to say that in terms of reconciliation, as just a snapshot view of what I think about the reconciliation, we have to first of all remember the colonial period. In the colonial period, there were massacres, slavery, forced transportation, dispossession, and all sorts of horrendous crimes against humanity, which we now try and sweep under the carpet. In the post-colonial period, there were concentration camps, restriction of movements with a permit system, marriage control, banishment, financial control and state theft. And I'll just tell you, I don't think I left it till later, the two things about the state theft. I had an elderly Aboriginal man come to me, and he said that he'd gone to inquire with the State Department about getting his money out of his fund. And he said, they told me there's nothing there. Now, this man had served Australia in the Korean War and was a war veteran. He had a rail pass, which meant he was entitled to free rail everywhere. And they said he used it all up on his rail passes, and also that he'd signed for it. And so he asked for the document where he signed for receipt of it. In this document, down the column alongside the payment records, for the signature it had an X. He could write his own name. He was a literate man. He was a poet and a literate man. And there was just a complete fraud and a theft by the state. Now, we made a letter of demand, they made an offer. He was old and sick, and he took the offer. Now, from my point of view, I wished he'd fought on, but he didn't, because he wanted to get what he could while he could. The other one was another lady who was a poet and a very respected lady. She got to the age of a mature age, where she then did a search on her file with the State Department. She found that when she was 18, the Workers' Compensation Board had paid to the protector, what a ridiculous word, anyway, paid to the protector an amount which was to compensate for the loss of her father, who died on a job site at work, and he was therefore entitled to the amount for workers' comp. So that the workers' comp had paid it to the department, and the department said that she got it. And she said, look, I was 18. If someone had given me a large sum of money like that at 18, I would have remembered. So anyway, she was very ill and she was old. So what I did, I did an affidavit by her swearing to the fact that she had never received the money, and we filed it in the court. And I said to the state, now I filed this affidavit, she's not very well, she may pass, in which case you should, if you want to cross-examine her, do it as soon as possible. They didn't avail themselves of it. In due course, she did die. Her son then took over the administration of the estate, and he came to me to act as the administrator in the estate. And so we then had a sit round with the state lawyers around the table, and they looked at me and they said, now that she's gone, you haven't got a witness that she didn't get the money. How evil is that? They waited for her to die, thinking they'd get away with it. And then I said, yes, but you see, under the Evidence Act, I filed an affidavit deposing as to that fact, gave you the opportunity to cross-examine her. You didn't take the opportunity, you threw away your chance. I can rely on the affidavit, which is unopposed. So they agreed to pay it after all, and that went into the estate. But how evil is that, to actually know that someone's dying, deliberately wait till they die in order to try and avoid paying money that you know is just and truly owing. Anyway, that's that. There was also wrongful imprisonment, as I mentioned about relatives. Mentioned about the verbals, but also another thing I found is that police didn't care if they got the right person, as long as they got any Aboriginal would do. And what I found unfortunate, sometimes if the coppers got and grabbed Bill Smith and said, we're going to charge you with this, he would know that his brother Joe Smith did it, but he's not going to tell the coppers. So he would wear it and go to jail. And from the coppers' point of view, they didn't care if they had the right person or not, as long as they got somebody. So they were locking up people who hadn't committed crimes, which then, of course, lets people who had committed the crimes escape, which only contributes to make the crime situation worse. Now, of course, the other thing is there was segregation, and segregation in this instance means you have the Vagrants Gaming and Other Offences Act said, by the definition of a vagrant was, and there was a long list, one of them was to be found in the company of a native without having good excuse or remaining there longer than necessary. So in other words, police would go around and frighten white people into not associating with Aboriginal people because they could charge them with vagrancy. And of course there was also things like insufficient lawful means of support. So you'd get a situation, for example, fellow going back to Woorabinda, gets to Duringa, misses the bus, sitting in the street, they pick him up, where's your money? Haven't got any money? All right, you're a vagrant, 6 months jail. That's a terrible thing, unbelievable. Anyway, now, additional factors are that, of course, if there's no justice, if a whole section of the community knows that they cannot get justice, would you expect them to cooperate? Would you expect them to say, oh dear, I better not go and steal off Woolworths or Coles because that would be bad? I mean, why wouldn't they? And of course, then you've got the intergenerational post-traumatic stress disorder of people seeing their parents, seeing their father humiliated and demeaned by police or government officers and so forth, and disempowering men. They disempowered men. In fact, I'll talk to you shortly about my first visit to Cherbourg, where clearly the men who were on the council, who were supposed to be the authority of the community, had no authority at all, couldn't speak to disagree with the manager or the superintendent, because terrible things could happen to them. So they disempowered the men, and the other thing is that children didn't want to go to school, because if the children go to school, they get taught that people have all died out and disappeared. Used to eat grubs, lived in the bush, gone now, end of story, and were ridiculed and teased and put down. And then, of course, at the legal service, we found in 1973, Matt Foley, as the social worker, as he then was, later the Attorney General of Queensland, Matt Foley came to me one day and said, "Do you know they're locking up Aboriginal children in Westbrook Detention Centre for truancy?" Now, first of all, as a lawyer, I said, well, I suppose if they're in need of care and protection. He said, yes, but you know that there's no education there anyway. And so what they were doing was finding a means of jailing Aboriginal people as of a matter of course, when there was no justification whatsoever for it. And of course, then what happens is, if a kid spends a whole lot of time in Westbrook, he learns how to be a criminal, he learns not to trust the system, he learns how to ultimately become an admittee to Boggarrow Jail, and then, it just goes on and on. Now, there's also a lack of housing and employment opportunities, under award wages. They weren't paying award wages to people, and they stole people's money, stole wages, and for example, the stolen wages issue at the moment, one of the things that has to be dealt with, and that is Torres Strait Island adoptions. Torres Strait Islanders have a customary law arrangement about adoptions. Now, if there's somebody's died and they've stolen wages going to be paid, then does the adopted child have a right to get that? Or not? Because if it's not registered according to the laws of Queensland and it's a customary law adoption, it's probably not going to be recognised. So even at this moment, there's a potential for injustices being done unnecessarily. Now, of course, the other thing is that there were poor health facilities. In fact, there was this is a story about a lady who was a teetotaler, never drank alcohol. One day she was going to walk towards her car for the family to go out on a picnic. And as she walked towards the car, she tripped, fell forward, and the aerial of the car pierced her eye. And it just went inside the eye. So they took her down to the local doctor. The local doctor said, this could be serious. You really should go to hospital for observation, because it could touch the brain, could cause an infection in the brain. So she goes to the hospital. Anyway, she was there for a couple of days, and they observed her condition as being speech slurred, unsteady on her feet, not focusing clearly, all these sorts of things that you might think is alcohol, getting off the withdrawals of alcohol. And so they didn't do anything until on the third day. Finally, they got a specialist to see her, and he said, we have to get an MRI done to see if there's something gone wrong in the brain from that car aerial. So they scheduled, because all the staff were knocking off early, they scheduled it for 9 o'clock the next morning. She died 9 o'clock that morning. Now, quite clearly, she would never have died if she had got proper medical care, and she didn't get proper medical care because of the stereotype prejudice against Aboriginal people, where they assumed that she was just alcoholic and stuff like that. So now, the consequences of these sorts of things to the community is that the state government was deliberately, in my view, creating the image of Aboriginal people as criminal. Because if you've stolen their land and you've treated them like rubbish and put them in concentration camps and so forth, it's much easier if people regard them as criminals in the ordinary course of events. And so that was part of it. And in fact, every time anyone went to court in the district or Supreme Court for a serious offence, the prosecutor would read out the antecedents, which is basically how old they were, where they grew up, where they were born, work, things and stuff like that. But there was also one that said whether they were an associate of criminals and Aboriginals. In other words, they defined Aboriginals and criminals into the same category. Now, imagine this all creates a very high crime rate, and leads to many innocent victims, non-Aboriginal people in particular, who are victims of crimes that should not have happened but for the system that the state government created. And that, of course, then increases insurance premiums, creates an enormous expense on the community of the time spent of police and courts and jails in prosecuting and jailing people. The enormous expense of that is another waste of resources of the community. I remember thinking one time there was a particular family, quite a large family, of about 6 kids or something. All of them were in and out of court, in and out of jail all the time. Because what's in it for them? They're not going to get a job, they're not going to get any respect, they're not going to get anywhere in life. So what have they got to lose? And I thought to myself, you know, if the state government had bought that family a house at a particular point in time, they probably would have saved the taxpayer millions of dollars in what it cost police chasing, prosecuting and jailing those kids. Now, the other thing is that they created in Aboriginal people a self-identification of themselves as criminals. And so there's no fear in going to jail. I saw one fellow one time in a pub shouting everybody. So I knew him very well. So I said to him, "What happened to you? How come you're shouting everyone? You have a big win." He said, "No." He said, "I'm going to jail on Thursday." I said, "Well, what are you going to jail for?" He said, "Not paying me fines." I said, "Well, why don't you use the money to pay your fines?" He said, "I'm not giving those my money." No, I'm not going to say what he actually said, but he described what he thought of white people anyway, but he's not going to give him his money. And anyway, he said, "I need to dry out and I can go visit my uncle." Because everybody had friends and relatives in jail. And some of them wanted to dry out. And why would they pay fines anyway? So, I mean, the whole system employed by the state government was to create crime. And the reason they were doing that was because they'd stolen so much from Aboriginal people, not only the land, but also the wages and all those other things as well. Now we come to the magistrates. First of all, you've got to remember that until the Goss government, magistrates were not lawyers. They were public servants. They would get a job in the public service, they'd get an appointment into the clerk of the court's office in the Magistrates Court registry, they'd work their way up to become clerk of the court, and then if they'd shown themselves to be truly dedicated to the Conservative Country Party government and obedient to the government, then they'd be appointed as a magistrate.
Well, I don't want to disagree with you, but they did have to have a law degree even then.
No, they didn't.
Up until Goss.
Up until Goss, yeah. Well, Bill Mackay didn't have a law degree. Webster didn't. I'll correct myself and say there may have been some, and there may have been some that were good, but
Certainly didn't know what it was like to be a lawyer.
That's right. But if they did have a degree, then they got it after they became magistrates, not as a prerequisite of being a magistrate.
Yeah, we're talking in the 80s, huh?
Yeah. And now, in fact, I was going to say one of them, Viv Gillingwater, for example, one of them in a break actually was talking about my client and referred to him as being Neanderthal, which I thought, the idiot doesn't know what a Neanderthal is anyway, really. I mean, it's just a slur. And another one, Bill Mackay, one time he was berating this child on a plea of guilty in the children's court. And he went and he said, "How would you feel if someone broke into your house and stole your valuable property?" And then he stopped and looked at me and said, "He's not listening to me." And I said, "Oh, Your Honour, I think the problem is that I don't think he's got any idea of what it would be like to own a house." This is from Cherbourg, by the way, or to have any valuable property. So he said, "Oh, yes, of course, yes. Supposing you did have a house and supposing you did have a lot of property," and you think, it just went completely over his head, thick as 2 planks. But my favourite one was another Gillingwater one, I think it was, where they'd arrested an Aboriginal girl for some street offence of some sort, but it had happened earlier on, and they'd seen her and she'd run away or something, and then quite like an hour or two later and some distance away, they saw this girl and arrested her. Anyway, she gave evidence as it wasn't her. Anyway, in his decision, the magistrate said, and I quote, "For an Aboriginal girl, she's actually quite attractive, and therefore it's very unlikely that the police would have made a mistake in identification." Now, these were the sorts of people who were making decisions. Now, I tell you what, you could never get one of them to believe the word of an Aboriginal against the word of a policeman. Never. Mind you, there were some good ones. I remember the fellow John Beck in Harvey Bay one time. I was appearing before him for these children who had broken into the pub and sold a lot of alcohol. Anyway, in my submission I said, well, when it comes to restitution, I said, even if they could pay, we do challenge the amount that's been claimed by the public. They didn't take anything like that quantity. The magistrate looked at the kids, looked at the distance they had to travel, looked at the amount claimed by the pub and said, I recommend that the police investigate the hotel for an insurance fraud. Because that's what used to happen too. The pubs would just make an exotic figure and get the insurance company to pay, and then somebody go through court and they'd smooth it all over and no one would worry about it because it was part of the scheme of the rich getting richer and the poor being used against them. Now, one of the things I would remind somebody back in 1978, an organisation called FARA, the Foundation for Aboriginal Islander Research Action Limited, conducted a survey throughout Queensland on the proposed changing of the legislation, because the 1971 Act was due to be reviewed, and we went round and I was fortunate to be the lawyer involved in it. Now, when it came to the publication of the research, it was in a book called Beyond the Act. And I wrote a little paper in it calling for the need for a treaty. And my argument is that so much evil has occurred in the past that if we're going to want to move on to the future, then we need to rule a line on the future, and the only way you can do that is to have a treaty where the Aboriginal people are involved in reaching an agreement as to what the future is going to be and how we resolve those issues from the past. And it still hasn't happened. But it's going to happen. It will happen eventually. Now, I want to talk about the people who would oppose treaty and reconciliation. The Bajolka-Peterson regime, for example, they knew the facts. They were not ignorant but well-intentioned. They were not well-intentioned at all. They were greedy, evil people. And they were just justifying or hiding the evils of the colonial period. For example, the Minister for Aboriginal Affairs was in New Zealand, the State Minister in New Zealand, and he was being interviewed on the radio. And he said, do you know, he said, Aboriginal people don't need money. He said, they just go out and hunt a goanna and they give them a cotton frock and they're happy. And of course, when he came home and people here said, oh, what a stupid thing for you to say. He said, but I didn't think anyone would hear. I was in New Zealand. You know, that's the kind of level of intelligence of these people. Now, in the modern day, of course, we've got the Pauline Hanson type. They're getting too much. We should all be equal, but I mean, what about the handicap? I mean, the Aboriginal people start from a serious handicap. If you were running a 440 race or something, and your opposition's going to be starting sort of 200 metres behind you, is that a fair race? It's not, and that's why a treaty has to be dealt with, trying to bring things up. Now, I was going to... How am I going for time? All right. I want to tell you about my first visit. I'm going to tell you my first visit to Cherbourg. I was only a young student, 22 or 21 or 21 probably, and Pastor Don Brady, who was our version of Martin Luther King, and Dennis Walker, our version of Bobby Seale, who they were going up to visit Cherbourg and asked me to go for a ride. Now, I won't go through the whole story because it's a bit drawn out, but when we got there, we ended up sleeping on the side of the road, and I wondered why, because no one actually really explained to me the permit system. And so I just went along with them. I mean, Don Davidson's family, his country, his family, I'll just go along with him. And Dennis didn't know much because he's from Stradbroke Island anyway, so we camped on the side of the road until dawn. Then at dawn we drove in. Then we went to the house of these relatives, and it was a tiny weatherboard cottage with no lining inside, extremely cold, full of people, but everyone was out the back round the fire. So I was sitting on a log round the fire, and here I am drinking tea out of a jam tin because I didn't have cups, and we're all using jam tins as cups. And suddenly the Aboriginal police pulled up alongside the fence near where we were. And they called me over, and I went over, and they said, "You got to go down the office." And I said, "Why?" They said, "Because you're driving round." And I said, "What's wrong with that?" He said, "Sergeant doesn't like it." I said, "Why doesn't the sergeant like it?" They said, "Because he's mad." I thought, well, this is a bit bizarre. So I went back to Don and Dennis, and they said, "We'll go down with you." So we went down to the office, and there was a small room, probably a third or a quarter of the size of this room, no furniture except one desk and one chair, and lined up on one wall was Dennis and Don and I. Lined up on the other wall were 4 or maybe 5 men, Aboriginal men, who were the council of the thing, and sitting behind the desk at this chair, the only furniture, was the manager, a little white fella whose name was Harry Mickle. Anyway, he started on me and he said, "You can't come in here," yeah, rah, 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 rah. And every now and then he turned to these men along the other wall and say, "Isn't that right?" And they all just nodded. And the whole conversation was him turning to them and saying, "Isn't that right?" And they all just nodded, and I thought, this is weird. This is what, you know, that movie, One Flew Over the Cuckoo Nest? The Indian who pretends to be deaf and dumb to get through the ordeal? Well, I figured that's exactly what it was like in Cherbourg. And anyway, eventually I said to him, "Look," I said, "I don't understand what this is all about. I mean, we only came to visit this man's relatives." And he said, well, "How long are you here for?" And I said, "Well, we only come up for a day trip." He said, "Okay, I'll give you a permit, but only till sundown." I thought, this is a crazy place. Now, because the way things were going on, in 1971, the Brisbane Tribal Council people had a demonstration. They marched down George Street to the office of the State Department of Aboriginal and Islander Affairs. I think it was, might have still Native. They kept changing the name all the time to try and make it sound better. But anyway, and they were all outside, and the police came, and they were having a bit of a chat, a bit of a demonstration. They wanted to kill Courtroom, and he was the director of the State Department. I tell you, I never heard any Aboriginal ever speak well of Courtroom, I tell you. Anyway, they had a bit of a thing, and the police went to grab Steve Mann. And Steve is a big Torres Island fella, and his wife, who's an Aboriginal lady, Pam Mann, she was a Bligh from Palm Island originally. She, when they went to grab Steve, Pam hit the copper with a handbag. So then they went to grab Pam. So then they had to grab Steve, and Don Brady came in swinging punches, and everybody's into it. And Don Brady's kids were all over in Queen's Park getting out iron spikes from the gardening stuff to get ready to defend themselves. And Dennis Walker jumped up on top of a car to address the crowd, and the car drove up and sent him spinning into the air. Anyway, they arrested a whole lot of people. Anyway, everyone got fines, and Pastor Brady got a fine, which he refused to pay. He said, "I'm not going to pay it. I'm going to go to jail," as a matter of principle. Now, he was a Uniting Church minister, which made it a little bit complicated for the state government to be arresting Uniting Church ministers. And so what then happened is Senator Neville Bonner paid the fine, so to get to remove the problem. Now, but in every level of things, the state government operated adversely to Aboriginal people, every level. Now, for example, we wound up attacking the probation office on one occasion because Matt Foley was the social worker at the legal service, as I said, and he developed the first stage of writing social work reports to go to court. So when we go to court, we'd present a report from our social worker which analysed what had gone wrong with the person's life and recommended what should be done to try and prevent a recurrence and recidivism and so forth. And he said this particular boy should go to, I think it was a country town in Western Queensland where he had family. He said the problem was that he was living in a nala, and because he was in a nala, he was hanging around with other kids who were doing all this stuff, and if he stayed in a nala, he'd get into more trouble. Anyway, the probation officer said no, he wanted him to stay at a nala so he could keep an eye on him, because the probation office couldn't actually extend themselves to operate to supervise somebody in a country town. They only did it in the city because people in country towns probably didn't break the law or something, I don't know. Anyway, so he wound up staying at Anala, committed another offence which brought him back for breach of probation. So we got a leading barrister to appear. We gave notice that we required the probation officer for cross-examination, and we instructed this barrister to get stuck into them. And his name was Don Horton. And he got really up there, and when we were sitting there, I looked around, and the whole of the back of the court was full of probation officers come up to see what the hell was happening, because they'd never been attacked like that before. And but it was good from then on. Every time Matt Foley wrote a report recommending something, it'd be pretty good if we'd get it. We also had to attack the Department of Social Security, because in those days what they used to do, if an Aboriginal mother with a couple of kids was living in a house and there was an adult male in the house, they would say, oh, well, you're in a relationship, therefore you're not entitled to a supporting parents benefit. Despite the fact that because of the lack of housing, they're overcrowded, every house had more, lots of people in it anyway, it didn't make a relationship at all. So Matt Foley organised a demonstration at the Department of Social Security, as a result of which a whole lot of people were arrested. So when it came to trial, we set them down for trial, and I served a notice on the director of the Department of Social Security telling him that he would be required for cross-examination. Anyway, he rings me up and said, I don't have to come to court. I said, if you don't come, I'll ask for a warrant for your arrest, so you must come. So he came, and of course he had to walk through this whole mob of people screaming abuse at him, and he came into the courtroom and pleaded with the magistrate to be allowed to go, and the magistrate, as I said, magistrates in those days, the magistrate agreed with him and let him go. As he was coming out, he said to me, see, I told you I didn't have to come. I said, yes, but we've got 14 more trials yet, so you'll have to turn up for each one of those. So next thing I know, they come to me and they say, listen, I'll make you an offer. If 2 people will plead guilty, we'll drop everybody else. So then you get the mob together and you say, what do you all make about it? And somebody say, well, I'm not worried if I get a conviction for this anyway, nor am I. So we got 2 and they pleaded guilty, and that was the end of that. Now, a lot of people that you had to attack was landlords. I had a fellow, now I've said the name of this fellow in the book because I had his approval and his family's approval. That's Sid Coolwell from Strait Island, had a house in Kennedy Terrace, Red Hill. Anyway, he'd rented it off this landlord, and the landlord gave him a notice to quit to get out. And he brought me the notice and showed me the notice and said that I reckon when I went in there, I was paying too much rent. And I said to him, to the landlord, I said, why is the rent so high? And the landlord said to me, because you're paying off the house. So he reckoned, I said to the landlord, can you put that on the receipt? So the landlord wrote on the receipt, part payment purchase of house. Anyway, so in law, of course, what we've got an agreement in writing, partly performed, and so we took a read out specific performance to get the house. And the ultimate resolution of it was that he did get the house at fair market price, as it was, minus all his rent payments. Anyway, I mean, and of course that was Sid, lovely fellow Sid. Anyway, another one is at St George. This is 75. I went out there because there was always lots of people in court. Anyway, this young lady charged with disorderly conduct, and that was nothing much to worry about. But the police, when they arrested her, took her to the police station, and when they took her out of the car, they got one on each ankle and dragged her on her back along a long concrete path, ripping her back open, raising her back. So after we'd finished in court, I think we got found not guilty or something, but anyway, whatever it was, I then took her around to the courthouse and took out a summons against the 2 police officers for assault occasioning bodily harm. Anyway, it was wonderful, because the next time I went out to court, the 2 cops had to stand in the dock, their solicitor in front of them defending them, and ultimately it went to a committal hearing, and at the committal hearing we retained the services of the top QC in crime at the time, Des Sturgis, and a matter of, this was to be in St George, and a matter of about, I think less than a week beforehand, he rang and said, no, I'm sorry, I won't be available. Now, to try to get a very senior, experienced criminal lawyer to go to St George on a few days' notice, it's really not easy. We found out later on that he was actually under a permanent retainer from the police union. And he should never have taken it in the first place. But anyway, but he was the hero of everybody at the time. And so we got a friend of mine, who's Neil Woodgate, who was a prosecutor and then a defence counsel with Public Defender's Office. But he'd had a bit of a mental health breakdown and had only just come out of a mental health treatment. So he came out and ran the thing. And of course what happened then, that the two police officers, one was a detective, and in fact, that detective, you ever look at this thing to do with Lindy Chamberlain, how that whole thing arose was from this particular detective who was stationed in Mount Isa, who went to interview them and tried to twist everything around to make that she was the killer. And that was the same detective that we had in the dock in St George. Pity we didn't win, it might have saved Lindy Chamberlain too. But anyway, the two top QCs came to appear for the two lawyers, and they crucified our girl in court. They just ripped into her, made a mess of her evidence, and ultimately the magistrate, again, decided that her evidence was so unreliable no jury could possibly convict, which was really stretching the imagination anyway. I mean, she did have an injury, they were the only ones there. I mean, really, again, it was a magistrate of the type that you would never put on the bench now, you know. One of the features of a Mergen Magistrates Court, it was nothing to have 50 people in court on a Monday morning, and a lot of them were drunks. Anyway, I'd have to be there Monday morning sifting through all 50 people to see what we could do with whom and what. And of course with the drunk parade, I'd go along the drunk parade and I'd basically say, were you drunk, were you drunk, were you drunk, were you drunk, were you drunk? If anyone said no, sit down for hearing. Anyway, one day, now I understood he was a deaf mute, and I'm not sure if he could hear a little bit, but he certainly couldn't talk. Anyway, he, at one stage I went, were you drunk? And he went, and so I sat down for hearing. Which then meant that that they had to have a magistrate set aside a day in court. They had to retain the services of a interpreter. Sorry?
A signer.
Yeah, an interpreter. And they had to have the police there to give evidence. And so we're there and they're going on and on and on, till eventually my client's in the witness box being cross-examined through the interpreter, until eventually he started making all these strange sounds and stuff, and the interpreter then turned around and said, oh, he's just said he's sorry, he made a mistake. He was drunk that day, he thought you meant a different day. So what can the magistrate do? He can't send him to jail. All he could do was say, oh, convicted and not otherwise punished. But they got to know that if they did anything, if they did arrest someone who wasn't drunk at all out of spite or wrongdoing, that there would be consequences to them. And that was a good start to it. But
was the interpreter Aboriginal or?
No.
No, see, that's the thing. No, we know who you're talking about, and we used to stay never drank.
Well, he's long gone. He's long gone now. It was
and we can pick up everything, and he can even talk. I say, oh, he certainly.
Well, it was Stanley Narang.
Yeah, that's it. So we could. That's why I'm saying, you know,
because he used to come on late sometime at the men's quarters where he's staying, and he knew the caretaker there, and we lived across the road, and we could hear it, he'll call out, Rory! So one of the crows opened the door, and he's coming, so there was somewhere to out loud.
And he was a lot.
Changed his speaker. Why do you think he'd say?
Well, he never drank. He was never drunk. He
Is
was
it
never
too
drunk.
late, do you think?
Sorry?
Why did he change his plea? So he was just
I don't know.
Just to please them.
Yeah, well, I don't know. I mean, the problem was that when you're dealing with 50 people, you know, you do tend to rush a bit sometimes, and truly there are a lot of situations I now think, I wish I had more time to do something different. I'll come to a couple of those soon.
The magistrates had never had a client, so when I was hearing for defendants at legal aid Ipswich, you'd be called in when you'd only done about 10% of your talking to clients. And I'd say, well, I'm not ready. And the clerk would say, well, do the ones you've done. So then you've got people waiting for you. They might get tired and go away. So that's why they had no idea what you're trying to do.
Yeah, that's right. The other thing, by the way, the other thing about the 50 people in court was that the rule was that the sergeant's wife had the contract to provide the meals to the prisoners. So the sergeant obviously wanted that there would be as many people as possible in the watch house, so his wife would be making money from making the meals, you know. I mean, this was Mergen, you know. The other thing, on one occasion, I took on an argument about alcohol in sport, advertising the alcohol in sport. And what had happened was there'd been a fight on the night of the State of Origin. And I didn't say this while the thing was on. It was a plea of guilty, I think, and after it was over, he finished the sentence and he was just about to adjourn. I said, now, Your Honour, before you adjourn, you have the power to make a recommendation to the government to change certain things. Now, you'll note on this occasion, this was the night of the State of Origin, and I reckon you'll find that most people practising in this jurisdiction would agree that there's more drunken violence on the night of a State of Origin than probably other night of the year. And if you watched that game, you would have seen 4X in the middle of the ground, wines around the bar, whiskey and everything advertised, slabs of beer on being raffled and all this sort of. It was all focused on alcohol. And then you are encouraging the situation that young people think alcohol have got to be a part of sport. Now, Your Honour, you can be courageous and you can make a recommendation. He scurried out. You've never seen a judge move so fast to get out of the courtroom. But on another occasion, I took on the other thing. The Aborigines Act of 1971 provided that the minister could make regulations with respect to peace, order and discipline of the community. And consequently, one of the regulations was that no one was allowed to be in possession of alcohol in the Aboriginal community. Now, that was a regulation, but I argued that there was nothing in the Act to give them the power, 5 minutes, yeah, to give them the power to make that law. And so I actually took a proceeding and we wound up where a barrister from the state government appeared on the argument. And he said, and the judge said, the district court judge said, this is too serious for a district court judge. It's really got to go to the Supreme Court, full Supreme Court for a ruling on something like this. And the barrister for the state stood there and said, Your Honour, if you will adjourn it sine die, which means indefinitely, then I will undertake to bring this issue before the full Supreme Court. What they did, it was a lady, Cynthia Malone from Cherbourg. And she only had an empty bottle anyway. It wasn't even. Anyway, so what happened is the state then took it on by writ of certiorari to the full court, and they quashed the conviction on the basis that she was not a resident of Cherbourg under the terms of the definition of the Act, and not on the electoral roll, and therefore they didn't have power to deal with her, and so they got rid of her for that reason. And that issue has never been dealt with, and in my view, all of the convictions of all of the Aboriginal people in all of the Aboriginal communities from 1971 till 1984 were all unlawful. All the alcohol had to be returned, and all the fines had to be reimbursed, and so forth. Now, I've got to get to the end of this, so can I tell one more about Cherbourg? Because all right. 1980. Cherbourg, in the South Burnett region, the grand final was between Kingaroy and Cherbourg. And the star setter for Cherbourg was a fellow Arnie Murray. And 2 days before the grand final, he came up on a charge of disorderly conduct before Bill Mackay. And what happened was there'd been a bit of a scuffle in the pub and between him and another Aboriginal fellow, another footballer, and there was no great consequence. The state didn't make a deal out of it, but with disorderly conduct it was, so fair enough. In those days, it was standard penalty, $20 in 1 month to pay. Anyway, the magistrate, Bill Mackay, fined him $100, no time to pay. So I couldn't believe it. So I got Arnie, took him in the waiting room, in the interview room rather, and said, wait here, I'm going to put in an appeal downstairs and get bail from the clerk of the court. But the police came to the room before I even said it all to him and said, we're taking him. I said, you give me time to do this. And they said, no, Mr. Richards. The warrant's already ready. It was prepared before court. The car's sitting outside waiting, the engine's running, the man's ready to take him, and you're not getting him back for Bogger Road for Saturday. They said that to me. What they did, the magistrate and the police conspired to pervert the course of justice in order to try and help Kingaroy beat Cherbourg in a bloody football game. Anyway, it just so happened, as often in Aboriginal affairs, some little miracle happens, and it just happened that morning on the way to court, someone had given me $100 cash to pay me something they owed me, and I didn't think about it, hardly ever, I don't think it ever happened any other time, and I shoved it in my pocket. So when the coppers came and said that to me, I was so angry, I was good. So I pulled the money out, the $100, shoved it at them and said, take the effing money. Anyway, so they had to let him go. They went across to the police station, took out a summons against me for obscene language in a public place. which they had to drop because the interview room was not a public place, and even if it was not obscene in the context. And so, but the best part was, when it came to the grand final, guess who won? Arnie Murray busted their back line all the time, and Cherbourg won handsomely. But for me, the greatest fun was going up to the bar, because the coppers had to stay up around the bar. So every time I'd go up to get drinks, I'd say to them, who do you think's going to win? First of all, they'd say Kingaroy. And then after a while, I'd go back up and say, now tell me again, who did you say was going to win? Because I'm getting cheeky then, because they couldn't leave the bar and everyone was watching, so they couldn't do anything to me. But look, look, my book's there, and there's lots more stories like that. I probably would just finish off a couple of things I'll just finish with. I was going to go on about native title, but that's a bit complicated. I'll do a couple of short ones. Many years ago, the Aboriginal Housing Service in Brisbane, the federal government stopped funding them because they'd sold a house without permission. So we had this meeting where I turned up for the committee of the housing co-op, and the bureaucrats were there, and I said, well, now they can sell any houses they bought before 1981 because that rule didn't come in till that year. So what they can do is I can advise them that they can sell those earlier houses and then use that money to buy a house right next door to the Premier of Queensland, and they can put in the biggest, most noisy, messy, blackest family they've got in that house. Then the value of that house, the Premier's house, will go down. In fact, all the houses in that street, their value will go down. They can use more of that money to buy up more of these houses, then move all of the people out to nicer houses, and then sell all those houses back at the full market value. I reckon they make enough to cover what you're not giving them. And they were horrified. Hey, oh, that's all right, we'll restore the funding, don't worry, you know. So, I don't know. Now, I was going to do a thing where we all split up and had a little thing, but I think we've gone too far for that.
We really enjoyed it.
We've got to push you back.
Well, what I'm going to, in conclusion, I just want to say this, that it's been nearly 50 years of involvement, and the progress that Aboriginal people have made themselves on their initiative, on their strength. Marshall.
Well, as you know, the class action was handed down for the stolen wages, and the government only come forward with 190 million. But Roz Kids in their thesis said the government's collected over 500 million. So what's going to happen with the 310 million? Do we have a leg to stand on? I see it as a take it or leave it offer.
I think you're right, because the problem is the limitation period. Unless there was legislation to remove the limitation period, people won't succeed in suing. And that's right. And it's not fair, but then, you know, I've never seen, I mean, the government's not fair, that's the way it goes. But anyway, I'm going to say, I mean, I think it's amazing. I mean, now, you know, when I went to publish my book, I had got 55 Aboriginal people who were referred to indirectly or directly in the book to check it all first. Secondly, I went to some really significant Aboriginal people like Dr. Valerie Coombs, Dr. Stephen Hagan, Dr. Chris Zara, Dr. Jackie Huggins, and Tony McAvoy QC, and got them to view it and talk back to me about what they thought I should do. So the process involved a lot of consultation. And for a non-Aboriginal person like myself to write a book about Aboriginal people is something that's fraught with great danger and difficulty. And I want to assure you that I have very thoroughly consulted to have the authority to be publishing this book and saying those things, and also proud that when I go back to the beginning of the book, there were no PhD Aboriginal people. There were no, in fact, Tony Mackin was the first QC, Aboriginal QC in the history of Australia, And we've only just, last year had Nathan Jarrow appointed as the first judge in the history of Queensland and the second judge in the history of Australia. And now, of course, we've got Aboriginal radio and Aboriginal TV. And the other thing that I've really been thrilled about is the acknowledgement at the beginning of so many things, like superannuation conferences. They begin by paying their respects to the traditional owners. Nothing to do with Aboriginal affairs. It's become the courtesy offered by Australia as a whole to the First Nations people to acknowledge that in so many situations. And I think that's amazing now, because I wouldn't, going back 50 years ago, these things you wouldn't have dreamt about, you know, amazing things. So I want to conclude by saying how grateful I am to so many wonderful, wonderful Aboriginal people that I've known all these years, and to congratulate them on a wonderful progress they've made, and to thank you for your very kind attention.